सो हेलो एवरीवन, माय नेम इज़ प्रीतम एंड आज जो है हम ए आई बी ई 8 का जो प्रीवियस ईयर क्वेश्चन पेपर है उसको एनालाइज करते हैं और उसको सॉल्व करके देखते हैं। बेसिकली मुझे भी सारे प्रीवियस ईयर क्वेश्चन पेपर जो हैं ए आई बी के वो सॉल्व करने थे, तो मैं सोच रहा हूँ कि साथ में आपको भी इंक्लूड किया जाए और आप भी इसको थोड़ा देखो समझो। अगर आता है तो फिर तो आपको नीड नहीं है, बट इन केस नहीं आता है, रिवाइज करना चाहते हैं तो आप ज्वाइन कर सकते हैं। ठीक है, तो स्टार्टिंग में हम सबको पता है इंपॉर्टेंट इंस्ट्रक्शंस होते हैं, जैसे ब्लैक पेन यूज़ नहीं करना है, ब्लू पेन और ब्लू बॉल पेन यूज़ करना है। एक क्वेश्चन जो है 1 मार्क्स का होगा, नेगेटिव मार्किंग नहीं होगी, 3 घंटे का पेपर होगा। और और भी कुछ एलिजिबिलिटीज़ जो होती हैं वो सारी मेंशन्ड होती हैं। ठीक है, तो ये तो हो गई हमारी बेसिक इंस्ट्रक्शन जो हम सभी को ऑलरेडी पता है। ठीक है, उसके बाद टोटल 100 क्वेश्चंस होते हैं और जैसा कि हमें पता है कि नेगेटिव मार्किंग इसमें नहीं होती है। और मैं एक बात आपको इन्फॉर्म कर दूं कि मुझे भी ये जितने क्वेश्चंस हैं नहीं आते हैं, तो मैं भी सॉल्व ही कर रहा हूँ। मेरे साइड में आंसर कीज़ मैंने ओपन कर रखी है और मैं साथ में यहाँ पे रीड करूँगा, साथ में जो इसके जो करेक्ट आंसर है उसको साथ ही साथ मैं टिक भी लगाता चलूँगा। ठीक है, और स्पीड अगर आपको मेरी स्लो लग रही हो तो आप प्लीज़ उसको थोड़ा फास्ट कर लें, अपने अकॉर्डिंग एडजस्ट कर लें। अगर फास्ट लग रहा हो तो स्लो कर लें। सो अपने अकॉर्डिंग उसको मैनेज कर लें, ठीक है, टाइम सेविंग के लिए। अगर आपको सारे क्वेश्चंस ऑलरेडी आते हैं तो फिर तो आपको मतलब इसकी रिक्वायरमेंट है ही नहीं आपको। बट इन केस नहीं आता है और आप चाहते हैं कि रिवाइज कर लें साथ में, तो आप डेफिनेटली कर सकते हैं। सेट जो है हमारे पास, सेट ए मैंने ऑनलाइन डाउनलोड किया था, सेट ए मुझे मिला है। AIBE 8 आप देख सकते हैं, यहाँ पे मेंशन्ड है। फर्स्ट क्वेश्चन है, मियर इलेगिलिटी ऑफ द स्ट्राइक डज नॉट पर से स्पेल अनजस्टिफिएबिलिटी Justice Krishna Iyer, in which case declared so. Mere illegality of the strike does not per se spell unjustifiability. Justice Krishna Iyer, in which case declared so. ऑप्शन हमारे पास चंद्रमलाई स्टेट वर्सेस its workmen. Option B, Associated Cement Limited versus their workmen. Option C, Gujarat Steel Tubes versus Gujarat Steel Tubes Mazdoor Sabha. Option D, Indian General Navigation of Railway Corporation Limited versus their workmen. Right option is option C, Gujarat Steel Tubes versus Gujarat Steel Tubes Mazdoor Sabha. Question number second, entry number 22 of the concurrent list deals with option A, social security and insurance, employment and unemployment. Option B, industrial disputes concerning union employees. Option C, trade unions and industrial and labor disputes. Option D, regulation of labor and safety in mines and oil fields. Right option is option C, trade unions and industrial and labor dispute. Question number 3, which article under the Constitution of the India talks about the participation of the workers in the management of industries? Option A, Article 43. Option B, Article 43A. Article 43B. Option D, Article 42. Right option is option B, which is Article 43A. So basically 43A talks about Constitution of India talks about the participation of workers in the management of industry. So participation of workers in the management of industries is mentioned in Article 43A. Okay. Next question है, pick out the case that is popularly called as the solicitor's case. Option है हमारे पास ऑप्शन ए, अहमदाबाद टेक्सटाइल इंडस्ट्रीज रिसर्च एसोसिएट वर्सेस स्टेट ऑफ बॉम्बे. ऑप्शन बी, नेशनल यूनियन ऑफ कमर्शियल employees versus option B है नेशनल यूनियन कमर्शियल एम्प्लॉइज वर्सेस इंडस्ट्रियल ट्रिब्यूनल बॉम्बे. ऑप्शन नंबर सी, सालेम एडवोकेट्स बार एसोसिएशन वर्सेस यूनियन ऑफ इंडिया. ऑप्शन नंबर डी, सेंट्रल मशीन टूल्स इंस्टीट्यूट वर्सेस डिप्टी रजिस्ट्रार ऑफ ट्रेड यूनियंस. फोर्थ का राइट आंसर है ऑप्शन बी, नेशनल यूनियन ऑफ कमर्शियल एम्प्लॉइज वर्सेस इंडस्ट्रियल ट्रिब्यूनल बॉम्बे. Question number 5. Identify the case that is related to the need for promotion and preservation of internal democracy within trade unions. हमारे पास ऑप्शन है ऑप्शन ए जय इंजीनियरिंग वर्क्स लिमिटेड वर्सेस स्टेट ऑफ वेस्ट बंगाल. ऑप्शन नंबर बी रेलवे यूनियन वर्सेस रजिस्ट्रार ऑफ ट्रेड यूनियंस. ऑप्शन सी ओएनजीसी वर्क्समैन एसोसिएशन वर्सेस स्टेट ऑफ वेस्ट बंगाल. ऑप्शन डी हनुमंथा राव वर्सेस डिप्टी रजिस्ट्रार ऑफ ट्रेड यूनियंस. फिफ्थ का राइट आंसर है ऑप्शन डी Hanumantha Rao versus Deputy Registrar of Trade Union. Question number 6. In tort, there are two broad categories of activities for which a plaintiff may be held strictly liable. Option A. Possession of certain animals and abnormally dangerous activities. Option B. Assault and battery. Option number C. Battery and negligence. Option number D. None of the above. Right answer is option A. Possession of certain animals and abnormally dangerous activities. Next question is question number 7. Selvi's daughter Kavita had married Siva Kumar of a different caste against the wishes of her family. Siva Kumar was brutally killed in 2004 and Selvi and two others become the suspects. Since the prosecution's case depended entirely on circumstantial evidence, it sought the court's permission to conduct polygraphy and brain mapping tests on the three persons. The court granted permission and the tests were conducted. When the result of the polygamy test indicated sign of deception, the prosecution sought the court's permission to perform narco analysis on the three persons. The magistrate directed the three to undergo narco analysis. All of them challenged this decision in the Karnataka High Court but failed to get relief. They then went to appeal to the Supreme Court. The court held option A compulsory brain mapping and polygraph test and narco analysis. It's difficult to pronounce this word for me. It's narco analysis narco analysis. ओके सो इसमें जो फर्स्ट ऑप्शन है मैं एक बार फिर से क्वेश्चन रिपीट कर देता हूँ. वर्ड क्या था? नार्को एनालिसिस. ठीक है, क्वेश्चन फिर से एक बार रिपीट कर देता हूँ. सॉरी, ये थोड़ा वर्ड है, इसमें स्टक हो रहा हूँ मैं. क्वेश्चन थोड़ा लंबा है, लास्ट के 3 लाइन्स रिपीट कर देता हूँ. All of them challenged this decision in the Karnataka High Court but failed to get relief. They then went in appeal to the Supreme Court. The court held option A compulsory brain mapping and polygraph tests and narco analysis were in violation of Article 20 Clause 3 and Article 21 of the Constitution. Option B compulsory brain mapping and polygraph test and narco analysis were valid under Article 20 Clause 3 and 21 of the Constitution. Option number C compulsory brain mapping and polygraph test and narco analysis were in violation of Article 20 Clause 1 and Article 21 of the Constitution. Option number D compulsory brain mapping and polygraph test and narco analysis were in violation of Articles 14 and Article 21 of the Constitution. आई एम सो सॉरी, ये क्वेश्चन मुझे काफ़ी बार रिपीट करना पड़ा है और इसमें थोड़ा मम्बल भी हो गया हूँ मैं, तो उसको प्लीज़ वो स्किप कर देना. 7th का राइट आंसर है ऑप्शन ए कंपल्सरी ब्रेन मैपिंग एंड पॉलीग्राफ टेस्ट एंड नार्को एनालिसिस वर इन वायलेशन ऑफ आर्टिकल 20 clause 3 and 21 of the Constitution. Question number 8. According to Article 71, disputes arising in connection with the elections of President or Vice President are to be inquired into and decided by option A the Supreme Court, option B the High Court, option C both by High Court and Supreme Court, option D tribunal established for that purpose. 8 का right option है option A the Supreme Court. Question number 9. The Water Prevention and Control of the Water Prevention and Control of Pollution Act 1974 relates option the discharge of hazardous pollutants into the nation's surface water, option B the emission of hazardous air pollutants Option C, waste disposal of sea. Option D, the transportation of hazardous materials. Ninth का right answer है option A, the discharge of hazardous pollutants into the nation's surface water. Question number 10. It was held by the Supreme Court that noise pollution beyond permissible limits cannot be tolerated, even if such noise was a direct result of and was connected with religious activities in the case of option A, well, Lord Citizens Welfare Forum versus Union of India. Option B, Church of God Full Gospel in India versus KKR Majestic Colony Welfare Association. Option C, Rural Enlightenment Kendra versus Union of India. Option D, Narmada Bachao Andolan versus Union of India. 10th का राइट ऑप्शन है ऑप्शन बी, चर्च ऑफ गॉड फुल गॉस्पेल इन इंडिया वर्सेस केकेआर मैजेस्टिक कॉलोनी वेलफेयर एसोसिएशन. Question number 11. The Supreme Court observed where an enterprise is engaged in a hazardous or inherently dangerous activity and harm result to anyone on account of an accident in the operation of such hazardous or inherently dangerous activity resulting, for example, in escape of toxic gas, the enterprise is strictly and absolute liable to compensate all those who are affected by the accident, and such liability is not subject to any of the exceptions which operate vice versa the tortious principle of strict liability. In such a case, the measure of compensation must be correlated to the magnitude and capacity of the enterprise, because such compensation must have a deterrent effect. The largest and more prosperous the enterprise, the greater must be the amount of compensation payable by it for the harm caused on account of an accident in the carrying on of the hazardous or inherently dangerous activity by the enterprise. Name of the case. Option A, Subhas Kumar versus State of Bihar 1991. Option B, Rural Litigation and Enlightenment and Entitlement Kendra versus State of UP 1985. Option C, MC Mehta versus Union of India 1986. Option D, Union Carbide versus Union of India 1984. 11th का right option option C, MC Mehta versus Union of India 1986. Next question, question number 12. Article 48A and Article 51A Clause G were inserted in the Constitution by which amendment? Okay, options हमारे पास by 42nd Amendment 1978, by 42nd Amendment 1976, by 43rd Amendment 1978 और by 44th Amendment 1978 of Constitution of India. 12th का राइट आंसर है ऑप्शन बी, द कॉन्स्टिट्यूशन 42nd Amendment Act 1976. Next question. Question number 13. According to Environmental Protection Act of 1986, environmental pollutant means option A, any solid, liquid or gaseous substance present in such concentration as may be or tend to be injurious to environment. Option B, any substance present in such concentration as may be or tend to be injurious to environment. Option C, any solid, liquid or gaseous substance present in such concentration as may be or tend to be injurious to a person. Option number D, any solid, liquid or gaseous substance present in such concentration as may be or tend to be injurious to the society. So this one is talking about the environment, this one is talking about same environment, this one is talking about injuries to a person, injuries to environment, injuries to environment, injuries to person and injuries to society. 13 का right option है option A, any solid, liquid or gaseous substance present in such concentration as may be or tend to be injurious to environment. Question number 14. A is in possession of property claimed by B and C adversely. A does not claim any interest in the property and is ready to deliver it to the rightful owner. A can institute dash suit. Option A, friendly suit. Option B, caveat. Option C, interpleader. Option D, restitution. 14 का right answer option C, interpleader. Question number 15. An executive magistrate may require security for keeping good behavior from habitual offenders for a period not more than option A 6 months, option B is 3 months, option C 1 year, option D 3 years. And the right option is option D, which is 3 years. Next question is question number 16. The police officer executing the warrant may use adequate force to access access the place where search is to be conducted when option A a free ingress is not possible. Option B, the occupant of the place is a hardened criminal and there is possibility to escape. Option number C, the area is in such a nature that problem may arise at any time. Option number D, none of the above. And the right option is option number C. Sorry, option number A, which is a free ingress is not possible. Next question is question number 17. As per the provision of the Code of Criminal Procedure, in case of merger of the complaint with the police report, the procedure to be followed for the trial shall be of option A, the complaint case, option B, the case instituted on the police report, option C, both as per the convenience during the trial, option D, none of the above. And the right option is option number D, option number B, the case instituted on the police report. Next question is question number 18. Peak versus Gurney is a famous case relating to option A mistake, option B misrepresentation, option C fraud, option D frustration of contract. 18 का right option है option number C fraud. Next question. Question number 9. Law is conceived as a form of the power value conceived by option A Bentham and Austin, option B Hart, option C Clausewell and McDougall, option D Carl Olive Crona Carl Olive Crona. 19 का राइट आंसर जो है राइट ऑप्शन जो है हमारे पास वो है ऑप्शन सी क्लासवेल वर्सेस मैकडोगल. Question number 20. The development of the tradition of the natural justice into one of natural law is usually attributed to the option number A Stoics, option number A, option A Stoics, option B positivist, option number C historical school, option number D analytical school. 20 का राइट ऑप्शन है हमारे पास ऑप्शन नंबर ए स्टोइक्स. Question number 21. The requirement to give reasons in administrative decisions which affect rights and liability has been held to be mandatory by the Supreme Court in dash. Options है हमारे पास एस एन मुखर्जी वर्सेस यूनियन ऑफ इंडिया, ऑप्शन नंबर बी स्टेट ऑफ ओडिशा वर्सेस डॉक्टर बीना पानी देई, ऑप्शन नंबर सी स्टेट ऑफ महाराष्ट्र वर्सेस जलगांव म्युनिसिपल काउंसिल, ऑप्शन नंबर डी मोतीलाल पदमपत सुगर मिल्स कोऑपरेटेड लिमिटेड वर्सेस स्टेट ऑफ यूपी. 21 का राइट ऑप्शन है ऑप्शन नंबर ए एस एन मुखर्जी वर्सेस यूनियन ऑफ इंडिया. क्वेश्चन नंबर 22. डोनोग मोर कमिटी रिपोर्ट ऑन मिनिस्टर्स पावर्स 1932 relates to option A England, option B Australia, option C USA, option D none of the above. 22 का राइट ऑप्शन है ऑप्शन नंबर ए इंग्लैंड. Question number 23. Section 47 subsection 3 of Motors Vehicle Act empowers the Regional Transport Authority to limit the number of stage carriage permits. Explain the nature of the function exercised. Option A. This is a judicial function as the authority's decision is based on an official policy. Option number B. This is a quasi-judicial function as the authority's decision is based on an official policy. Option number C. This is an administrative function as the authority's decision is based on an official policy. Option number D. None of the above. And the right option is option number C. This is an administrative function as the authority's decision is based on an official policy. Next question is, in which famous case this issue had come up, whether the advocate had committed a professional misconduct and is guilty of the offense of the criminal contempt of the court for having interfered with and obstructed the course of justice by trying to threaten, overawe and overbear the court by using insulting, disrespectful and threatening language. Option number A Vinay Chandra Mishra in Ray. Option number B ex capt I don't know इसको ये क्या है कैप्टन है एक्स कैप्टन और So X kept Haris Upal versus Union of India. Option number C. Hikmat Ali Khan versus Ishwar Prasad Arya and others. Option number D, none of the above. And the right option is option number A, Vinay Chandra Mishra in Ray. Question number 25. Misconduct would cover any activity or conduct which his professional brethren of good repute and competency would reasonably regard as disgraceful or dishonorable. It may be noted that the scope of misconduct is not restricted by technical interpretations of rule of conduct. This was proven conclusively in the case of option A, Nora Tanman Korasia versus M.R. Murali. Option number B, Bar Council of Maharashtra versus M.B. Dhabolkar. Option number C, in N.G. Dastane versus Srikant S. Sindhe. Option number D, B.M. Verma versus Uttarakhand Regulatory Commission. इसका राइट ऑप्शन है ऑप्शन नंबर बी, बार काउंसिल ऑफ महाराष्ट्र वर्सेस M.B. Dhabolkar. Question number 26. Retention of money deposited with advocate for the decree holder even after execution proceedings was held as an instance of misconduct, in which case option number A, in Re DC Saxena. Option number B, M Virendra Rao versus Tekchand. Option number C, Sambhu Ram Yadav versus Hanuman Das Khatri. Option number D, Prahlad Saran Gupta versus Bar Council of India. And the right option is option number D, Prahlad Saran Gupta versus Bar Council of India. Question number 27. In which case where the advocate of one of the parties was asking for continuous adjournments to the immense inconvenience of the opposite party, it was held by the Supreme Court that seeking adjournments for postponing the examination of witnesses who were present without making other arrangements for examining such witnesses is a dereliction of the duty that an advocate owed to the court, amounting to misconduct. ऑप्शन हमारे पास NG दस्तानी वर्सेस श्रीकांत S सिंधे. ऑप्शन नंबर बी, शंभूराम यादव वर्सेस हनुमान दास खत्री. ऑप्शन नंबर सी, नोरा तनमन Corsia versus M.R. Murali. Option number D, none of the above. 27 का राइट ऑप्शन है ऑप्शन नंबर A, N.G. Dastane versus Srikant S. Sindhe. Question number 28. The judgment in desk eschews the delicate balance carefully crafted by the model law and enshrined in section 34 between finality of arbitral awards on one hand and permissible judicial review on the other. Option A, Renu Sagar Power Cooperated versus Renu Sagar Power Company versus General Electric Corporation. Option number B, ONGC versus Pipes Limited. Option number C, Sundaram Finance versus NEPC. Option number D, Olympus Superstructure Private Limited versus Meena Vijay Khetan. इसका राइट आंसर है ऑप्शन नंबर बी, ONGC versus Saw Pipes Limited. Question number 29. The Supreme Court in Des held that irrespective of where the central management and control is exercised by a company, companies incorporated in India cannot choose foreign law as the governing law of their arbitration. Option number A, TDM Infrastructure Private Limited versus UE Development India Private Limited. Option number B, Comet Chemical Limited versus C. N. Ramachandran. Option number C, Sriji Carco Private Limited versus Paperline International Inc. I don't know ये क्या होता है Inc. Option number D, Bhatia International versus Bulk Trading. 29th का राइट ऑप्शन है ऑप्शन नंबर ए, TDM Infrastructure Private Limited versus UE Development India Private Limited. Question number 30. Which section of the 1996 Arbitration Act permits the parties to engage in conciliation process even while arbitral proceedings are on? Option number A, section 30, section 10, section 40 and or section 20. 30 का राइट ऑप्शन है ऑप्शन नंबर ए, section 30. Question number 31. The presumption of continuance of life is contained in section dash of the Evidence Act. Option number A, Section 107, Section 108, Section 207, Section 115. Presumption of continuance of life. 31 का राइट आंसर है ऑप्शन नंबर ए, सेक्शन 107. Section 107 talks about presumption of continuance of life. Question number 32. Testimony of a witness to the existence or non-existence of a fact or facts is in issue is or are A. Option A. Oral evidence. Option B. Original evidence. Option C. Direct evidence. Option D. Both A and B. Testimony of witness. ओरल डायरेक्ट एविडेंस. आई थिंक ओरल होगा. 32 का डायरेक्ट है. 32 का राइट आंसर है ऑप्शन सी, डायरेक्ट एविडेंस. क्वेश्चन नंबर 33. हु ऑथर्ड द बुक द फर्स्ट प्रिंसिपल्स ऑफ ज्यूरिस्प्रूडेंस? ऑप्शन ए सेलमोंड, ऑप्शन बी ब्लैकस्टोन, ऑप्शन सी अस्टीन, ऑप्शन डी विनफिल. 33 का राइट ऑप्शन है ऑप्शन नंबर ए, सेलमोंड. सो द प्रिंसिपल्स ऑफ jurisprudence is written by author Salmond. Question number 34. Special summons under section 206 of the criminal procedure code can be issued by option A magistrate only, option B a magistrate as well as the court of sessions, option number C the court of session, option number D the high court. 34 का राइट ऑप्शन है ऑप्शन नंबर ए, a magistrate only. सो स्पेशल समन की पावर जो है वो सेक्शन 206 में मेंशन है और वो केवल जो मैजिस्ट्रेट है उनके द्वारा ही एग्जीक्यूट करवाया जा सकता है या ऑर्डर दिया जा सकता है, ऐसा ये क्वेश्चन कह रहा है. ठीक है. नेक्स्ट क्वेश्चन है क्वेश्चन नंबर 35. मारे लिब्रम द फ्रीडम ऑफ सीज फर्स्ट पब्लिश्ड इन 1609 is a book in Latin on international law written by option A Austin, option B Hugo Grotius, option number C Arvid Pardo, option number D Stark. इनमें से जो राइट ऑप्शन है 35 का ऑप्शन नंबर बी, ह्यूगो ग्रोटियस. ह्यूगो ग्रोटियस. क्वेश्चन नंबर 36. The Indian who is presently a member of International Court of Justice? Option number A Justice A.S. Anand, option B Justice Bhagwati, option C Justice Dalveer Bhandari, option number D Justice Nagendra Singh. 36 का राइट आंसर है ऑप्शन नंबर सी, जस्टिस दलवीर भंडारी. नेक्स्ट क्वेश्चन है क्वेश्चन नंबर 37. इंटरनेशनल क्रिमिनल कोड इज बेस्ड ऑन ऑप्शन ए रियो कॉन्फ्रेंस, ऑप्शन बी रोम स्टैट्यूट ऑफ द इंटरनेशनल क्रिमिनल कोड, ऑप्शन सी पार्ट ऑफ यूएन चार्टर, ऑप्शन डी यूगोस्लोवाकिया स्टैट्यूट ऑफ द इंटरनेशनल क्रिमिनल कोड. 37 का राइट ऑप्शन है ऑप्शन नंबर बी, रोम स्टैट्यूट ऑफ द इंटरनेशनल क्रिमिनल कोड. Question number 38. Consecutive and delegatory theories of a state relates to option A law of the sea, option B law of airspace, option C law of outer space, option D state recognition. Right option is option D state recognition or state recognition. Question number 39. Tabula rasa under international law relates to option A state recognition, option B universal succession, option C state succession, option D sources of international law. 39 का राइट ऑप्शन है ऑप्शन सी, स्टेट सक्सेशन. क्वेश्चन नंबर 40. with reference to cyber crimes worm attack, option A needs the virus to attach, option B do not need the virus to attach, option C needs the host to attach, option D do not need the host to attach. 40 का राइट ऑप्शन है ऑप्शन नंबर डी, डू नॉट नीड द होस्ट टू अटैच. क्वेश्चन नंबर 41. An attempt to acquire sensitive information such as usernames, passwords and credit card details and sometimes indirectly money by masquerading as a trustworthy entity in an electronic communication is known as option A salami attacks, option B phishing phis- phishing, I don't know, it's phishing, and option C data diddling, option D forgery. 41 का जो राइट ऑप्शन है वो है ऑप्शन बी फिशिंग. Question number 42. The act to provide legal recognition for the transaction carried out by means of electronic data interchange and other mean of electronic communication commonly referred to as electronic commerce is dealt under option A Information Technology Act, option B Information and Communication Technology Act, option C Information Communication Act, option D Information and Cyberspace Act. 42 का राइट आंसर ऑप्शन नंबर ए इंफॉर्मेशन टेक्नोलॉजी एक्ट. Question number 43. Asymmetric crypto system under Information Technology Act means a system of a secure key pair consisting of a private key for creating a digital signature and option A an individual key to verify the digital signature, option B a lock to verify the digital signature, option C a public key to verify the digital signature, option D a government key to verify the digital signature. 43 का राइट आंसर ऑप्शन सी अ पब्लिक की टू वेरीफाई द डिजिटल सिग्नेचर. क्वेश्चन नंबर 44. सेक्शन 43A of the Information Technology Act deals with option A compensation for failure to protect, option A compensation for failure to protect data, option B punishment for sending offensive messages, option C identity theft, option D impersonation. 44 का राइट आंसर है ऑप्शन ए which is compensation for failure to protect data. Question number 45. The persons taking part in the commission of an offence have been divided into classes. They are option A principal and abettors, option B principal and disciples, option C principal and accessory, option D debtor and holder. 45 का राइट ऑप्शन है ऑप्शन नंबर ए प्रिंसिपल एंड अबेटर्स. Question number 46. What is the period of limitation prescribed for the suit instituted by a mortgager to recover possession of immovable property mortgage? ऑप्शन है हमारे पास 3 years, 10 years, 30 years, 12 years. 46 का राइट आंसर है ऑप्शन नंबर ऑप्शन नंबर सी which is ऑप्शन नंबर which is 30 years. ठीक है. Question number 47. Section 12 to 15 of the Limitation Act 1963 provide for exclusion of time in computing the period of limitation prescribed by law. Which of the following falls inside the ambit of exclusion? Option A day on which judgment, order or award is pronounced, option B time during which stay injunction operated, option C time during which the defendant had been out of India, ऑप्शन नंबर डी ऑल ऑफ दी अबव. 47 का राइट आंसर है ऑप्शन डी ऑल ऑफ दी अबव. Question number 48. Provisions regarding corporate social responsibility are incorporated in the Companies Act 2013 under Section 101, Section 101, Section 111, Section 135, Section 235. एंड इसका राइट ऑप्शन है ऑप्शन सी सेक्शन 135. ऑप्शन सी सेक्शन 135. Question number 49. What is the corporate social responsibility among the following? What is corporate social responsibility among the following? Option A employee benefits, option B project based protection of national heritage, option C programs undertaken outside India, option D mere donations. 49 का राइट आंसर है ऑप्शन बी प्रोजेक्ट बेस्ड प्रोटेक्शन ऑफ नेशनल हेरिटेज. क्वेश्चन नंबर 50. तलाक ए तफवीज इज तलाक तफवीज इज इज ऑप्शन है हमारे पास ए तलाक बाय डेलीगेशन, ऑप्शन बी ट्रिपल तलाक, ऑप्शन सी तलाक बाय एग्रीमेंट, ऑप्शन डी इम्प्रॉपर तलाक. एंड 50 का राइट ऑप्शन है ऑप्शन ए तलाक बाय डेलीगेशन. सो ये थे हमारे 50 क्वेश्चंस आज के AIB 8 के. और इसी के साथ हम इसको यहाँ पे स्टॉप कर देते हैं। बाकी जो 50 जो रिमेनिंग है 51 टू 100, सो 1 टू 50 हमने कर लिया है आज, और 51 से जो 100 है वो हम नेक्स्ट पार्ट में इसका कर लेंगे, ठीक है। तो तब तक के लिए आप सभी का थैंक यू।